Welcome back to Winning Isn't Easy. Let's talk about UNUM's objections to an ERISA's disability claimant's level of medical care during the COVID crisis and what one judge did. Now, even though this dealt with the question of the level of medical care during the COVID crisis, this is a continuing issue in most disability insurance claims. It's what is the level of care that's appropriate. And why is that important? Because many ERISA disability plans or policies require that the plan beneficiary or the policyholder get reasonable and appropriate medical care. And if you don't, one of the tools in the carrier's denial or termination toolbox is for them to take the position that you didn't get appropriate medical care, or that the level of care didn't rise to the level of your claimed disability. In other words, your lack of treatment is, or the nature of the conservative treatment is disproportionate to your alleged severity of the pain. Okay. Now, what they argue is if you were in the degree of pain that you say you were, or you had the degree of disability that you say prevents you from doing your own or any occupation, you would have gotten a greater level of medical treatment and you would have been compliant, very compliant. Now, disability carriers like UNUM are making that argument, particularly in cases where a person didn't get a lot of care during the pandemic. And let me tell you about the case of Graziano versus First UNUM. Ms. Graziano was a senior property underwriter for Swiss Re. Swiss Re is a reinsurance company. Many disability insurance companies, life insurance companies, will have multiple layers of coverage, and companies like Swiss Re provide this additional layer of coverage. Think of it like Lloyd's of London, if you will. They're also a person or a group that will carry this excess coverage. So there was an issue where this policyholder had low back pain, got cortisone injections and physical therapy and medication. UNUM merely paid him his benefits, did a life insurance premium waiver until they decided to deny his claim, in part on the basis that his attempts to get treatment for his condition were too conservative. They were inconsistent with the complaints of pain and ignored the realities of getting treatment during COVID. Now, using a de novo standard of review, the judge, I think, quickly dispatched UNUM's argument that the care he received was conservative, because that is the kind of care that one will normally see in the context of a back claim. Then the judge took on UNUM's argument that Graziano's condition was not severe and wasn't disabling, since he only got minimal care during the height of the pandemic. Obviously, he hadn't gotten physical therapy recommended by his pain management provider. He was concerned about contracting COVID. And that was particularly true since he suffered from comorbidities. He was obese, he had type 2 diabetes. And of course, that, as we all know, put him at an increased risk for developing COVID and with increased adverse consequences if he were to have contracted COVID. So UNUM said, your concerns about contracting COVID aren't credible because the relevant time frame related to the dispute that we're talking about was prior to the pandemic. Now, the court didn't necessarily buy that argument because they noted that prior to the onset of stay-at-home orders in March of 2020, Graziano was having ongoing conversations with his physician about the efficacy of in-person physical therapy. He was doing exercises at home, and he was exploring getting additional physical therapy prescriptions. Now, obviously, when the stay-at-home orders were lifted in October of 2020, he resumed physical therapy. The court noted that UNUM's peer review doctor faulted Graziano for not attending physical therapy in August of September, during the course of the pandemic and during the period of time when stay-at-home orders were still in effect. Of course, UNUM was then also arguing alternatively that he could have gotten a vaccine, but of course that wasn't necessarily available at that point. So in this case, the court accepted Graziano and his treating physician's explanations that his failure to attend physical therapy stemmed from his desire to avoid serious jeopardy from contracting COVID and not any improvement in his medical condition. Now, the court cautioned him and cautioned claimants, noting in its ruling that that shouldn't be construed as an endorsement that the absence of medical treatment like physical therapy, medication, or surgery would entitle a policyholder to benefits. Rather, the decision was limited to the combination of his active conversations with his physicians about the efficacy of physical therapy, the nature of the treatment plan, the fact that he was doing home exercises. And the court also looked at functional capacity evaluations that had been done relevant to this time frame that showed that he was working or performing at less than a sedentary condition. So the judge looked at the totality of his medical condition, the nature of the treatment that was being recommended, what he was doing at home, his concerns about contracting COVID, particularly because of the potential side effects that he would, or likelihood that he would develop COVID, and the particular side effects that he would be susceptible to, including death. So it was a great decision. But again, I want everyone to understand, you might have a medical condition like post-cancer treatment that could result in you being developing complications or infections that might be a reason for justifying you not attending things like physical therapy or other modalities of treatment. But that is only going to go so far. Regardless of the fact that you might be susceptible to infections, your immune system is compromised, that in and of itself is not going to excuse you from getting reasonable and appropriate medical care based on the level of severity of your medical condition. So keep that in mind as you're just trying to decide whether or not you're going to attend treatment that is being recommended, and how that can result in a claim denial and termination that could possibly be upheld by the court. We've covered a lot of UNUM games, but as I've said, these are games that other disability carriers play. So I hope you've learned a lot and enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, please like our page, leave a review, share it with your family and friends. Please subscribe to this podcast. That way you'll be notified every time a new episode comes out. I hope to join you next week and another episode of Winning Isn't Easy. Thanks.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.